Hi, folks. We're with Tacitus today. Tacitus today, your pushback channel, and thank you for joining this audio live stream. Please listen to this presentation as you would a radio broadcast. In this essay, I'd like to talk about the push that's on all across the Western world. I've made reference to this in the past, where in all the globalist-controlled Western white or hitherto white countries, the move is on to get rid of jury trials. So trial by jury is gone. So it's trial by judge only, unless it's an appeal court where there may be more than one judge hearing the matter. But now History Debunked, and if you haven't seen his channel, head on over there. History Debunked did a video on it recently, I think yesterday or the day before, and he's raised this and suggesting that it's somehow unique to Britain and unique to someone of Islamic origin, Sharia law origin, who's pushing for it in Britain, and that this is maybe not such a desirable thing given the person. But the reality is that it's happening all over the Western world and happening at about the same time, and the same language and justifications and talking points are being used all across the Western world. And it's also a thing that the globalists are coordinating, engineering, talking point formulation, the central secretariat, and so on. So this is not uniquely English or British at all. The same's happening here in Australia, Canada, and so on. Now, I guess, is this a good thing or a bad thing, doing away with juries or keeping juries? What's the most desirable thing? Well, legal verdicts that rely on facts and evidence are always the desirable thing. But we're looking at a different world today, where ideology and ideology around social power, that people with less social power should not be held accountable to the law. People with more social power should be held heavily and brutally accountable, and so on. So there's a huge amount of ideology. A lot of lawyers, judges, magistrates, prosecutors, district attorneys, as we see in the United States, the people are going after Donald Trump and going after Daniel Penny and that sort of thing. That ideology is certainly in the ascendant in most legal jurisdictions at the moment. So juries can be, to some extent at least, to break against that type of it's government tyranny. Let's call it what it is. If the government's coming after you and there are no restraints on them, then that's the practice and the success of tyranny in that regard. Now, at the time when monarchs and kings and so on were, maybe not all powerful, but certainly had great power to act arbitrarily and unilaterally, then not that they didn't have councils and advisors and so on, they did. And there were rare times when a monarch could go against the council or the advisors and say, no, I don't care what you guys are saying, I want to do this or that. That didn't really happen very often. And there were reasons why a monarch had more power at a certain time than they may otherwise have had. For example, the country may have been through a huge, very costly and damaging civil war. And so if the king starts throwing his weight around, the council and the council of lords and sort of thing may object to it and may not like it, but they think if they oppose the king too strongly, that it may end up tipping into another civil war, and they think, gee, we don't need that. So they'll concede ground to the king they may otherwise not. But anyway, so the balance of power between the lords and the advisory council made up of the lords and so on, and the monarch was constantly shifting and changing. Now in England at the time of the Magna Carta, part of the Magna Carta was people could be judged by their peers. Now this wasn't what the lords, the lords didn't want this as the way things should be. It was designed or thought up as a break against, or a barrier, a buffer against arbitrary power of the state, represented by the monarch in this case. So the monarch can't just declare somebody guilty in the sense of what is a court of attainder, 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 where you're predetermined as guilty. And Now, again, this waxed and waned over the centuries, so it didn't begin in around the time of Magna Carta. Well, one of the earlier, I think in England, it may have been one of the earlier, first jury trials was not long after the Magna Carta, within a few years of it. Bear in mind that the monarch King John attempted to renege on the Magna Carta, or certainly parts of it. So there was a lot of toing and froing, pushing and shoving about that as well. But the idea of a jury, that's what a jury was for. It was to break the ordinary power, the arbitrary power of the monarchy or the state. Now, it was believed at the time that the king could simply appoint a judge to hear the case, and the judge would be, in effect, what we call today an activist, representing the king's interests. So the judge was appointed to find the person guilty and throw them in prison. They weren't there to hear the evidence or weigh and balance the evidence or listen to the witnesses. They were there to do a hatchet job on the accused. Now, this was felt very keenly by the people at the time. And so again, they wanted that. So a judge on their own, that's no good. The judge can be easily corrupted, and it was the view at the time. And bear in mind, this is going back 1,000 years. This is where juries came in. So they're for that purpose. So they would have put a band-aid, put a sticking plaster over the problem of arbitrary state power. Now, we need to always understand that's the genesis of juries. Now, even before juries were in, there were other forms of what we today call an approximate jury, but applied differently. So if you wanted to bring charges against somebody, this is before Magna Carta, if you wanted to bring charges against somebody, in some districts, this wasn't uniform, and it was practiced mainly in the Anglo-Saxon areas of Britain. If you wanted to bring charges against somebody, then there was a council or a jury, in effect, was convened to determine the validity of the accusations. So the concern at the time was that false accusations brought by the king or the monarch or whoever it was, person with arbitrary power, the charges being brought against someone, that had to be examined to make sure it wasn't corrupted or wasn't personal or wasn't just a vendetta or somebody wasn't trying to stick it up a political opponent or something like that. So it was assumed that the initial problem with it all was the accusation and the validity of the accusation. So there's a council to do that. But going through time, the things like the writ of habeas corpus, where you can't just arbitrarily arrest someone and keep them in detention forever, like they're doing with the January 6th stuff in the United States, which is, in my view at least, effectively a wholesale suspension of habeas corpus. But various other facets of law came in, but the jury system continued in different forms, hardly perfectly. So it was an organic development over time, which depended on the relative power of the monarch, the power of the electorate, and the power of the lords. And so as that power shifted, then the use of juries similarly shifted. But it never went away that the state had the ability to corrupt judges and appoint corrupt judges and appoint, corrupt maybe is the wrong word, politicized judges that are there again to do the hatchet job on the accused. So the state can control the police force, so they can arbitrarily arrest someone on false charges. Then they can appoint a judge to do the hatchet job and throw them in prison. So juries were needed against that. Now, there were times when there was no police force. So the view of the government and indeed of administrative authorities and legal authorities too, England in say, I don't know, the mid-1700s. I'll use the mid-1700s as the beginning of the effects of the agricultural revolution. So people widely dispersed working on the land in little pockets here and there, to the Industrial Revolution, or the onset of it, or the agricultural revolution, which made farming far more efficient and on a bigger scale rather than small little strips of land here and there. And so they were sending, so a lot of people were being displaced from the land and going to what were then the cities. you could have cities that were, say, somewhere between 5,000 and 8,000. That within a short space of time, the population increased to 30,000, which of course is huge. So there's a big displacement of people from the rural areas into the urban areas. Now, this created a whole new set of socio-economic conditions. Now, there's no police force existed initially, at least until I think what was the 1840s or something in England. The government and the authorities generally decided, well, I know what we'll do. We haven't got a police force to go and investigate crimes, so we'll just make the punishment so severe that it'll scare the crap out of people and they won't commit crimes just through. So it was the crimes were brutal, public hangings, and for fairly minor crimes, minor theft, you could be transported to the colonies such as Australia, or Botany Bay as it was called in the time. And there are still signs around. I was driving around England some years ago, and at a corner of my eye, I caught a sign that was on a small stone bridge, which would have been in a rural area at the time. And the sign in old sort of English language, who shall, something to the words to the effect of, who shall soever injure this bridge will be transported to the colonies of Botany Bay. And the sign's still there. And but the death penalty also existed. Now, this is where jury trials sort of came in. If you were going to have a trial that involved people going to prison for more than a year or something like that, I think it was, or indeed the death penalty, death by hanging as it was at the time, then it had to be a jury trial. If you were going to kill someone or pretend, organising to kill them, that is, hang them for the crime, or put them away, deprive them of liberty, then you could have to do it by a jury of your peers. And I'll come back to that in a minute, but what judges found and what the authorities found back in the day, if they prescribed a heavy penalties such as hanging or such as 20 years in prison, juries wouldn't convict. They just couldn't get the juries to convict. The juries worked as a powerful counterweight to what I perceive as a state overreach of their power. So the state said, we can't be bothered with a police force, or maybe the concept of a police force hadn't sort of come to mind, and too expensive, and we'll have to introduce income tax. We do that, those sorts of things. And so if we have a police force, then that's one thing. But if we haven't got a police force, then we have to have terrible, way over the top punishments, and that will be the deterrent without the need for a police force. So that meant it was considerable overreach, and but juries would not convict, and this annoyed or irritated, I should say, the authorities at the time. Why won't juries convict? Now the juries aren't there to fall in line with tyrannical use of state power. They're there to now the argument was that the juries weren't actually deciding on the evidence, that is, did the person steal the loaf of bread? For example, did the accused steal a loaf of bread? They did. That kind of wasn't really in doubt, and was provable. So the jury objected to the overreach of the punishment. I mean, why would you hang somebody for a minor, what ultimately is a minor crime? And maybe in those days, the jury of the peers, everybody knew somebody who maybe was in a difficult situation that maybe would have also stolen a loaf of bread. Didn't really matter, but the jury thought, no, we're not going to convict, because if we do convict, they're going to kill this person, and we don't believe the punishment fits the crime. So the jury was making its own decision there, and this irritated the authorities no end. So the next fallback position was to say, well, we'll transport you to the colonies, Botany Bay, Australia, or the port of Sydney, which at the time was called, later on called Port Jackson. So, and Sydney was named after the Foreign Secretary at the time, Lord Sydney. So anyway, now transport to the colonies was considered a pretty scary sort of prospect, an unknown world. It was another planet as far as the people were concerned, it was a 4-month trip, across 18,000 kilometres or something like that. So it was a long, unpleasant trip, and then at the other end, a very strange land with sharks in the water and poisonous snakes and spiders trying to bite you. A long way from the green hills of England. So that was considered to be a pretty serious pain. But for that, the juries would convict if they were going. No, but you can't kill someone or lock them away forever. That the juries wouldn't convict them. Now, coming to the time, what were juries? Juries were made up of a jury of your peers. That's how it was written. Now, in a time when people didn't move around and they lived for generations and generations in the same place, a little bit different with the rural displacement of people into the cities. But once they moved into the cities, they then stayed there for years. So these were people who all knew each other, knew of each other, and they weren't moving around a lot. There wasn't this huge shifting population, other than that one, not that it was done in 5 minutes, but that one shift country to city in the agricultural and the industrial revolution. But even so, people, particularly in the rural areas, but people knew each other, that you were being tried by an action, not just a jury of your peers, as in people in your class of society, for example, but you're being tried by people from the village or from the town or from that suburb or that sort of thing. That's not the case today. That's very different today. So people moving around, whether it be for work or migration or whatever it might be, the idea of getting in a small, stable, fixed community, the idea of getting a jury of people from that such a sedentary population is very almost zero. So people aren't being judged by juries of their actual local, regional, geographical peers, and they may not be being judged by people that have maybe they're being judged by a group of ideological fanatics and so on. So the selection of the jury pool is far wider than ever was quite narrow, back in comparison, quite narrow back in the day when jury trials were the thing. Again, designed and put in place as a break against tyrannical state power, overreach of state power. So the juries today, and we can see with the jury that convicted Donald Trump in New York, it's not hard or difficult for the prosecution to arrange for and stack an activist jury. That they can do it if they want to. We're looking at a very different landscape today, legally all over. Activist judges, activist district attorneys, activist prosecutors. We look at the prosecutor in the Daniel Penny case. Could you get somebody more activist if you tried? I mean, you couldn't. It wouldn't be possible to find somebody more activist. And it's not difficult to put together an activist jury. Similarly, if someone's of limited financial means, the legal aid lawyer that's appointed to them will similarly be an agent of the state, not your representative, not your lawyer. They are an agent of the state. And increasingly in the globalist part of the world, the entire legal apparatus is people who, again, judges, prosecutors, DAs, and so on, are people who are agents of the state. They're agents of the globalist, not accountable to the people's state. And this changes the entire landscape of justice and how it's applied, and also changes the relevance of juries. So should a judge be hearing a case alone? Well, it depends on the judge now. We can't assume the judges are independent and impartial. Judges, brazenly activist judges are being appointed and preferred over constitutional or legal judges that will apply the law. And I've seen this up close, that talking to a number of not only sitting but former judges, is that among them they're just a bunch of activists. Now, if they get a case in front of them that they've got no sort of activist political relationship or there's nothing in it for them. There's no social power, or it's a straight issue of just hard details and no ideology. I'm sure they would make a decision based on the law, but given that they see the entire world and have been trained and have been handpicked because they see the whole world, an issue of social power and a sense of social power, then it changes the landscape in terms of the jury. So I think, my view is that juries are still needed, and also that there must be a redoubling of efforts to make sure the jury is absolutely impartial. It would be impossible on the fake charges they brought against Donald Trump in New York, these bookkeeping, accounting charges, the fake charges they brought against him, to have a unanimous jury verdict. It just simply wasn't possible unless you have a jury stacked with activists, and which is what they successfully did. How did they do that? And we also need to understand that activist judges are being handpicked to hear certain cases, that the administration, the clerk of the courts and all that sort of thing, the people that assign, say, to which judge gets what case, and which prosecutor and DA gets what, all that sort of stuff, that's all shot through with activists. So we need to understand that. So what we need is a break against, a buffer against the activists, and only a 100% impartial jury can give us that break against the tyrannical overreach of state power. Now, the globalists want to, because the control of the law and the legal machinery, the apparatus of the law, is essential to the globalists in imposing on us, because we've never agreed to it or voted for it, imposing on us the globalist project. And so as they go about that, they have to reduce the wild card, as the globalists see it, because they don't have the same control over a jury as they do over a judge. They can control the judge and the prosecutor and so on, but the juries are harder to control. There's a random element in that that they can't control. It drives them crazy too, by the way. So they want to reduce the amount of cases that are heard by jury. But in my view, if you're going to deprive someone of their liberty for more than, like with some sort of weekend detention or something, for a week, a few weeks, that's different. But if you're going to deprive someone of liberty for any appreciable period of time, or in the case of the United States, send them to the execution of some sort of electric chair or whatever they do now. If that's the go, then it must be a jury trial. Now, there are some instances where the trial by jury, say someone's been it's a complicated case of where some banker has been accused of some sort of fraud, say, and it's quite complicated, and the chances of a jury, rando picked jury, being able to follow that, the intricacies of the money trail, the chances of a jury being able to follow that are pretty slim. Not impossible, but pretty slim. So these are cases where a jury trial doesn't really work. Because the jury can't follow the facts or the evidence, because it's just simply too complex, where a judge can. Now, I don't agree that a judge necessarily can follow it, but let's suppose for a moment they can. But the jury can't follow it. How then can the jury make a decision given that level of complexity? Well, that's fine. I do get that. But then the punishment meted out to that person has to also be reduced and watered down, or not watered down, reduced to reflect the fact that they can't be judged by their peers, and they can only get a verdict from a judge. And unless they're quite well to do, they can't afford an appeal, of course. So then things like prison or those sort of things really have to be reconsidered. Maybe they get a period of home detention, for example. So I think the punishments need to be rejigged to reflect the fact that juries have been removed. But it's not a single issue that juries yes or no, or those. It's interlocking with many other issues and other matters. And for example, judges haven't always been rabid activists coming out of educational institutions that teach them that the entire Western world are all made up of Hitlers or something like that, or the social powers issue, and or the black people who can murder as many folks as they want, but they shouldn't really be held accountable because they don't have much social power. These sorts of things. Though those aren't issues today that we used to. The idea of an entire legal structure that's been created specifically for the globalist purpose is not something that we used to. And so juries, the relevance of juries as it was in the time of the Magna Carta, is relevant to the extent of and the nature of state power and its arbitrary application. For example, Daniel Penny in New York, the recent case that got worldwide coverage, that was the arbitrary power of the district attorney and the prosecutors. Under real life, normal conditions, there would have been oversight. No, you can't do that. No, that case isn't going to court. Or if you're going to put that case in court, then you must drag all black people into court, and so on. You've got social power is not an issue here, but they don't see it that way there. Social power is an issue. It is the issue. It's the only issue that should determine legal activity. And so we need to navigate through that, because this determination of social power and how it is the epicenter of how justice, as they would see it, is distributed, is the big issue. And and whether you want to call that overreach or tyranny, it doesn't really matter. It's folks applying arbitrary power to persecute private citizens who have not committed a crime, and that's the issue. And for that, we need juries. Now, the reason for juries may be a little different than it was at the time of Magna Carta or 100 years ago, but the use of juries as a break against tyranny is an absolute must. And on that basis, I would argue they should be kept. You've been fantastic today. Your Pushback Challenge. Thank you for listening.